Okay, so hello everybody. Welcome to the Yale Law School Information Society project. My name is Ge Chen, an ISP resident fellow and assistant professor at German Law School. I'm very honored today to moderate this event, actually a conversation between Professor Jack Balkin and Justice Professor Andreas Paulus, two leading constitutional lawyers from the US and Germany respectively. Professor Balkin is Knight Professor of Constitutional Law and First Amendment at Yale Law School. He's the founder and director of Yale's Information Society Project, an interdisciplinary center that studies law and new information technologies. He also directs the Abrahams Institute for Freedom of Expression and the Knight Law and Media program at Yale. And our guest today is Justice Paulus. He holds the chair of Public and International Law at the University of Göttingen, where he teaches public law, international and European law, and legal philosophy. Since March 2010, he has been Justice of the First Senate of the Federal Constitutional Court, the famous Bundesverfassungsgericht, which deals mainly with constitutional complaints concerning the violation of constitutional rights by public authorities. In 2003 to 2004, Professor Paulus lectured at the University of Michigan Law School as visiting assistant professor of law. And between 1999 and 2006, he was assistant professor at the University of Munich, where he received his doctoral degree and concluded his habilitation. He studied law in Göttingen, Geneva, Munich, and Harvard Law School. Justice Paulus has also served as counsel and advisor of the Federal Republic of Germany before the International Court of Justice in the case of LaGrand, Germany versus US, as well as certain property cases such as Liechtenstein versus Germany. So while the conversation is going on, may I ask our audience to mute yourselves, please. When it comes to the Q&A part, however, please use the reaction raise hand button on your screen, and I'll hand it over to you in the sequence of the hands raised. So without further ado, Jack and Andreas, floor is yours.
Thank you so much, Ge. Thank you, Justice Paulus, for joining us today. It really is a great honor to have you here. We're just delighted you could be here, especially because you're also an expert on law and technology and digital speech and privacy issues. So this is just wonderful. I'm going to start, however, by asking some very simple questions about the way the German Constitutional Court operates for those of folks in the audience who aren't from Germany and aren't aware, especially for the Americans. So the first thing is, I take it you have more than 9 justices on the Constitutional Court. Is that not right?
Well, that's right. Yes, absolutely. And let me first say that I'm very glad to be here. I have read your blog for decades. I'm a great admirer of the tenacity of writing a blog and maintaining a blog for such a long time. And it helped me very much, so I guess, to understand more about US law and constitutional law in particular. So I'm glad to be here. And secondly, on your question, of course, we have 16 justices, and they are divided in 2 senates, as we call them, 2 separate chambers. Chambers we have also because they are composed of 3 justices for dealing with minor cases that do not raise new issues. But some of those minor cases, as we may see in the discussion, are major regarding the topic, but not major regarding the criteria applied. And those criteria must be established for a chamber to sit. So we have a Senate and we have a chamber. The Senate is composed of 8 justices each. And originally the idea was that the first Senate would be dealing with issues of fundamental rights. And the second Senate was supposed to dealing with state matters. For instance, disputes between the federation and the lender, which are the states in the US context, regarding competences, regarding jurisdictional issues, or questions between the parliament and the executive branch according to the distribution of competences. Or, and that is the most important these days, the relationship between Federal Republic of Germany and the European Union or the broader world, international law, European law. Yeah. Of course, it hasn't worked as intended. First of all, the First Senate has decided that you can limit constitutional rights only when the law is otherwise also constitutional, giving it the power to review the constitutionality of the whole law and not only the issue before it. Secondly, the Second Senate, of course, at the beginning, it seemed that it would not get cases because apparently jurisdictional issues were less important to the lender. Like some of the states in the US, they would rather open their hands and ask for federal money rather than asking for competences. And therefore, the Second Senate got some rights cases, in particular regarding criminal law and tax law. And secondly, it also regarded rights questions in the cases coming to it. Today, both senates are busy. Both are busy. Both are dealing with rights. And we will later speak about the right to be forgotten. Maybe the First Senate is also and needs to taking account of European law and even international law. We are citing much more international law than we used to do 10 or 20 years ago.
Very good. Several other things that Americans might want to know about this court. First of all, not only does it have panels, 16 members, but they're term limited, like most sensible constitutional courts around the world. The American Supreme Court, as you know, still has life tenure, which I think if we were to do it over again, we wouldn't have today. Another thing that's really important about the German Constitutional Court is that many of the justices, like Justice Paulus, have scholarly backgrounds as legal academics and legal scholars. And you were just telling me you are still on the faculty of Göttingen, even while you were serving on the Constitutional Court. And then the final thing, which will take us to the first question I wanted to ask, is that the justices specialize, right? That is to say, there are justices who are put on the court specifically because they have a particular kind of expertise. And tell us a little bit about the expertise that you've been assigned on this court.
Well, thank you very much. Indeed, this is the only civil job you may do besides being a justice. The reason is also in the beginning, in the 50s, it was not so easy to get professors giving up their established positions and going to Karlsruhe to be a justice in a court which had at the time not the reputation it had today. It was a new thing. Nobody knew how it would develop. And therefore, they created those privileges to induce law professors to come to the court. And these days, of course, it's in dispute, as everything else always remains in dispute in constitutional law. There are no fixed conclusions, as you all know. It is not so different in Germany than it is in the United States. Speaking about this today is, of course, particularly vibrant. That means that today there is this academic tradition in the court. And maybe it is one aspect of the strength of the court. It has developed into a strength of the court. And also this change, there are enough examples of colleagues who were able to convince their colleagues of the time to implement their pet project of constitutional law, if you like. But the moment they were gone, those projects had a certain tendency to wane. And sometimes you have effects in areas you had never expected before. And you are not as successful in your favorite area because this is not so easily generalizable. And maybe future generations of justices are not as convinced as you are of your thesis. So you have to take into account that there have been great successes. You are standing on giants, on the shoulders of giants, firstly, and secondly, there are other giants coming after you. And so it can be a humbling experience. Nevertheless, this academic tradition is quite strong and lives on. Other things have not lived on. At the beginning, there was one female justice. Today, we are a majority female court. When I came into my Senate, I was the only, there was one single female colleague and 6 male colleagues. When I leave the court next year, there will be in my Senate parity between men and women. So all these things have changed, but this academic tradition has not. On the other hand, there are also 3 in each Senate, 3 justices coming from a background of one of the Supreme Courts in Germany. And that gets me to another point one has to realize. In Germany, we have not one Supreme Court as in the US, but we have a separate constitutional court. It is more the Austrian tradition, the Kelsenian tradition, which got us there. and not the one Supreme Court. But we have other Supreme Courts, a Supreme Court of Justice, for instance, which have to first give a judgment, and then parties can come to us complaining about violations of their constitutional rights and of their constitutional rights only. We deal, of course, with regular ordinary law, but we do not decide on issues not regarding constitutional law. So this may be the first specialization you were talking about, Jack, and this is a specialized constitutional court. Nevertheless, I tell you, I've never learned as much about the law, the ordinary laws of my country, than in those 11 plus years I have been on the court. So actually, of course, we develop expertise for ordinary law. But my expertise originally was indeed in international law, in human rights law, Charter of the United Nations, things like that. But of course, we had a general legal education. And we have state examinations, 2 of them. So actually every lawyer in Germany has to be knowledgeable, at least about the basics of law in general. And this expertise, of course, in a way shows. One of my colleagues is Susanne Baer, who is quite popular and known in the academic circles in the United States, in particular, of course, the legal circles. And she has an expertise in comparative law, and both comparative law and international law play a much larger role these days than this used to be the case. And of course, we have to add this big elephant, which is European Union law, which is gigantic. And maybe half of the law we are administering has some sort of European aspect to it. Anyway, so expertise plays a role. On the other hand, you have no right to deal with cases in your previous occupation. So I have started to become hopefully an expert in more than 10 years in copyright law. I had never dealt with copyright law beyond my own private issues before. I have done the law of levies. I was also not knowledgeable in that. At the beginning, I thought, oh, that is a strange mixture I'm having. Freedom of art, of course, is the nicest thing, although it's not as nice as it appears on first sight. But at first I said, this is a mixture, I get confused. But in the long run, I love this because it's really very diverse. Every case is different. Wonderful.
So I want to turn now to substantive areas of the law. And my first question has to do with the differences between how Germany and then in a larger sense, Europe are approaching the regulation of the internet and digital speech, and how America is. Now, there's some obvious differences. The Americans are very libertarian. The Americans have no hate speech regulation. The Americans don't have this sort of tiered relationship between national law and supranational law, European law. They don't have the multifaceted different forms of directive and regulation that you have in Europe. And finally, we don't have comprehensive digital privacy law. We don't have comprehensive privacy law, period, really, if you put it that way. So those are some obvious differences. But what would you say, in your experience, is the most important difference that people need to be aware of in the different, in how the general question of internet regulation is handled?
Well, there may be a big difference, and that is that we are in Europe in general and in Germany as well, working much more with codes and with written laws. And sometimes the regulation is coming before the issue has really become vibrant. So there is now a law on artificial intelligence debated. Of course, artificial intelligence is there already, but that you would make a law at this stage where a lot of things are uncertain would probably not occur to most Americans, and there would be no chance probably to get it through the Senate anyway, or the House. And in Europe, there is this regulatory apparatus where one thinks about how to regulate things, sometimes in advance. We had data protection laws, and in fact, we had a directive already in the 1990s. And of course, the new General Data Protection Act regulation is, the GDPR has become famous as a model of regulation even if some people may think that technologically there are others who are more advanced than the Europeans in the substance. But the regulation in Europe was much earlier than in other places, and is some sort of a model. Sometimes a positive, sometimes maybe also a negative model. Things at least you have to relate to before you make your own laws. You will look how the Europeans have done it and whether you like that or whether you are rather dislike it. And that may be a different approach, that we have those general codes, and it gets particularly difficult because we have these two levels, the European level and the domestic level. And sometimes the European level is first. In data protection laws existed in Germany already in the 1980s. And for instance, with regard to a regulation of social networks, there is a so-called network implementation law. Don't worry, don't try to understand what that means. It doesn't even make sense in Germany, this title, but what it is in fact is that network laws are to be enforced. So you can, implementation is a weaker word, you can also say network enforcement law, because they are obliged when there is a clear violation of criminal law, including laws you do not have, like hate speech. They have to refer the thing to the state, to a prosecutor's office, which then has to decide whether they will go against the author. And this obligation may transfer to the European sphere in the Digital Services Act, which is currently debated, but frankly speaking, far from being adopted. So this will also in Europe, of course, regulation is a year-long, if not decade-long effort. Still, we are quicker in that than the United States, for better or for worse.
Yes. I mean, you mentioned that the Network Enforcement Act, or NetzDG, as it's sometimes referred to. And here I actually want to spend some time talking about it, what it does, and how it's different from in ways that are unfamiliar to most Americans. So the first thing you mentioned is, of course, the referral process. But I think for most Americans, they'd be interested in the fact that it requires certain digital companies, not all, and certain social media companies, and not all social media companies, to put in place a system for identifying illegal content. Obviously, illegal content, which must be removed, I believe, within 24 hours, and illegal content generally, which should be removed within 7 days, something like that, right? So this is a very interesting system of public and private cooperation. Has this relationship between public state and private industry created any interesting legal issues in your view?
Well, yes, it has created a few issues. And my court actually will be the last one dealing with them probably in Germany. We have dealt with this in small cases. One small case regarding the removal of a political party from a network just before the European elections. And whatever you think of that party, we decided in a very brief order. It's not, it's not a full argument. It is only a provisional order. We said, don't do that before an election. Let's put them back. You do not have to admit also everything what they put on that network. There were things which were regarded probably as hate speech in Germany. You can remove those things which violate either federal laws, or we didn't speak about community standards yet, but we didn't exclude it. So if they are against your standards, you may remove certain sentences, certain phrases, but you should not remove them completely from the net, because participation in the political process and the democratic process in Europe is, of course, a right which should not be easily be done away. So that was in a brief order. The rest of our case law, which is discussed in this regard, is dealing actually with a completely different area, with banning a person from football stadiums, European football, soccer stadiums, who had become arguably violent, even if a criminal court had not put him into jail or had punished him, because they said there was not enough evidence. But the Football Association said he was a suspect was enough for them to invalidate his tickets for a couple of years for his favorite team and ban him from all stadiums in Germany for a couple of years. And we decided that, in fact, along with the decision, former decision of the Supreme Court, that you can ban somebody even if he has not violated criminal laws, or you can't prove that he violated criminal laws, but if there is some reasonable suspicion, but you need to have a procedure to do it. Who is the you here? The you was a football association. The you must be somebody who is not your baker around the corner, but somebody who has who provides a forum for public discussion and who has some sort of monopoly. I mean, you can only, as a football fan, you do not want to go to games of other teams. You want to go to your team only. So that's some sort of monopoly. And of course, watching football is, at least in Germany, an important thing for social integration of some people. For some people, it is almost a religion or a substitute for religion. So you see something which is important, and you have a social right. In fact, we cite the International Covenant of Economic, Social, and Cultural Rights for that. You have a social right to participate. And in such an instance, we said you have to provide a fair procedure, and that means at least you have to give the person the possibility to put forward his views and probably to go to court to reverse the decision of this forum provider. And of course, the Federal Supreme Court has then transferred in a certain way the logic of that decision to a network, a social network, banning a customer for alleged hate speech. And actually the court was leaning to the point that the hate speech was such, and that it may have violated community standards, but they said those standards in the general conditions put forward by the social network were not sufficient because they did not provide for a hearing of the banned party, and they needed to provide for that. And again, by the way, the public forum idea is, of course, an American idea and a Canadian idea, which we adopted in yet another case, dealing with freedom of manifestation, freedom of assembly in a public airport. So you see, there are a lot of cases relating together. We ourselves have not yet decided on that decision of the Federal Supreme Court. At the moment, it's usually those decisions of the Supreme Court stand. They are binding, but it may be or may not be that they are that there is somebody complaining that his or her rights were violated. Private parties can do that, and then they may come to the Constitutional Court.
Yeah,
actually, I have no idea whether that happened in that case.
One of the things that's remarkable from the standpoint of the American perspective is the notion that you are essentially delegating to an important private actor, in a football club in the first case, but a social media company in the other, the obligation to put in place a set of procedures for resolving questions regarding behavior in the case of the football club, and content published in the case of the social media center. And that, as I understand it, there's no direct right of action in the NetzDG against the social media company. An individual does not sue the social media company under NetzDG. Is that correct?
That has recently changed. They have modified that law, because that was one of the main charges against the law. I simply report that. I didn't give my opinion on this. Yes. But there was criticism raised. This is one-sided. You have only a right against, the network has, so to speak, a duty towards the state, but also towards protecting other users. But you have no right to ask to be published. If it is a public forum, then you should have also a right to be published, and not only an obligation not to engage in behavior against the community standards. That was partly rectified with a change in the law, which is very recent, and I think it just has entered into force. It was one of the last products of the past parliament. So we will have to see how this works out. They also corrected an error in the original law because they said, which is quite difficult. Maybe in America it would be easier, but in Europe there was a problem how to get to a social network, how to how to sue a social network in court. And the original law only mandated a focal point, so to speak, an address in your home country where you could put forward your claims against regarding this network enforcement law. But the consequence of the network enforcement law in practice was very often that the networks didn't enforce criminal laws, but they enforced their community standards instead, which were stricter than the general law, criminal law, of course. Because freedom of speech, of course, is also valid in Germany, even if we interpret it sometimes differently from our American brethren. And therefore, it was important that such an office is also open to all other claims against the network, and not only claims regarding the Network Enforcement Act, which only deals with criminal content.
Yes, it's really important.
If it is not openly criminal, by the way, just to explain the law, if it's not openly criminal, then you need to offer a procedure, a sort of, not unlike the so-called court of one of your networks, in the social networks in the United States. You can have a private body, an independent body evaluating whether or not that particular speech is hate speech, which is criminal, then they have to remove it or not. There are different options for the network. There may be a general arbitration providers, so neutral providers which are not part of your firm, but you may also do that within your own network if it is sufficiently independent. That's what the law says.
Yes, I think it's also important from an American perspective to understand NetzDG aims not at only aims at criminal content that is illegal under German law. And that raises very interesting issues with respect to disinformation, which is something that Americans are increasingly worried about, because not all disinformation, I take it, is illegal under German law. That is correct, right?
Right, yeah, right. There is such a law. And actually about fake news, if you like, wrong information, there is still another player around in Germany. We are a federation, as you know. So we do not have only the European Union, which is something between a federation and a confederation. We have a German word for it, which is not translatable, Staatenvereinigung. But we have also states. We have also Länder in Germany, they're called. And for part of the media, it's their responsibility. There's a famous case on that a federal news channel or federal television channel was illegal because the federation could not have its own channel except for foreign use. And so the Länder have concluded a treaty among each other. We call it treaty, like international treaties. And with regard to media regulation, which is also, it builds on the previous treaty of that kind, but it is pretty new, and it has a provision regarding those posts which are pretending to be from a real person, but in fact is simply a duplication or a product of artificial intelligence or what have you, of a foreign service wanting to influence an election, for example. And they try to ban these kind of messages, but this is also a controversial issue.
Absolutely. Another thing that's worth emphasizing is that NetzDG does not reach any number of things that Americans would think of as social media. So my understanding is the private messaging services, Telegraph and Signal, these are not, in fact, covered by NetzDG. That's correct, yes?
Yes, they're under sort of privilege for providers which are not content providers themselves, and the networks are considered to be, they have their own community standards, actually, which were at some point some German lower courts were of the view that those community standards were inadmissible because it is a public forum. They wanted to treat it like the state. The Federal Supreme Court has rejected this view now. And has referred to our case law on that. Whether that is good or bad is something I cannot speak about today, obviously, because it may come before my court, even if I'm not on the court anymore. It would be not appropriate when I would talk about it here, about my own view. But my own view is not important. Important is that the Supreme Court's view is that that is that community standards are okay if they are not overbearing, if they are still giving everyone a fair chance. We have in Germany a right to equality, to equal treatment, also addressed to the federation. And this right to equal treatment is, according to this jurisprudence of the Federal Supreme Court, borrowing from our jurisprudence on the stadium ban thing, is to be applied to customers of social networks. So they are not treated as a private person. If we create our private network, those rules will not apply. But if we admit all students of the world, then of course we may fall under the social networks criterion, and then we may be covered and have to report all sorts of violations of the law.
Yes, and also relatively small, still small social networks are not covered by NetzDG, which means ironically, perhaps, or not ironically, depending on your view, that the new social network that former President Trump is trying to create, which he calls Truth, the Truth Network, until it reaches a certain size, it will not be covered by NetzDG either.
Well, that's of course true. I'm not sure how many customers such a service would have in Germany, but you never know.
You never know, indeed. Now I want to switch from a legal question, a constitutional question, to what I might call a larger philosophical question. So I hope this is something that you can offer your opinion on. It seems to me that we are moving from a world in which the state was the primary ensurer that a speech was within the boundaries of the law and within social norms, to a system in which these large private entities, social media companies, are basically the front line of enforcement with respect to the norms regarding speech, either because of their own individual terms of service and community standards, or because they've been given the task by Germany and also the European Union to enforce the criminal law. And as a result, the form of justice and the form of rights protection they will offer is going to be tailored to the fact that they are private organizations. And as you said before, they have a choice as to many different ways in which they can fulfill that obligation. Moreover, they're probably going to use systems that are completely unlike the systems that we associate with the state, that is individualized consideration. They're going to engage in algorithmic determinations about removals. They're going to engage in probabilistic determinations about removals. And so this is a very different way of thinking about and enforcing norms than we are used to, at least are accustomed to in modern liberal states. And this is not a legal question, but a philosophical question for you. Should we be sad, happy, indifferent, shrug our shoulders and simply say, well, that's the way the world is and it's going at this turn of events?
Well, I would say, of course, this is a very deep and important question you could reflect on for a long time. On the one hand, we have to take it as it is. There's no alternative. It's not that we can do away with all this, although there has been a certain rehabilitation of the state recently. Secondly, I would observe that I have realized far too late, to be frank, that the new world in which every person has a chance to express him or herself and is having a lot of followers, as we call them in some networks, that this is not only a liberating experience, like, finally freedom of expression is really getting through because there are no intermediaries preventing us from expressing our views. If you write to the editor decides whether he will carry your letter, etc. pp. We have done away with editors in those social networks, although these networks are now playing sometimes the role of the editor, and it's not quite yet clear whether they want to be an editor or simply a carrier. In that regard, it depends also on the network, which of the two they want to be. But suddenly we realize that those editors have done mostly or often good work, that some of the what we now call fake news or wrongful messages or simply disinformation on vaccines and on illnesses and on behavior, whatever, would not have come through. They would have remained in a small private confines, and frankly speaking, some of those messages would have better remained there. And now they are in the open. That's bad sometimes for the person who has made these remarks, but it has societal consequences which are incredibly large. And who had thought that 20 or 30 years ago that a president of a country would be banned from, at least temporarily, from some of those public spaces where we have our sort of discussions. So yes, I would say this is a new world, but I would also say, maybe that's typically European, but I would also say it proves that we still need somebody who regulates, and somebody from the outside, some legitimated entity, and that gets into the picture of democracy. Actually, my court was quite strong in saying freedom of expression is of course a value in itself, but it has also giving a huge service to democracy, and democracy cannot thrive and work if new views cannot be expressed because they do not find somebody transporting them. So yes, freedom of expression is a tool of democracy, but democracy has also to look at those tools and has probably a say in how they are working, and should see to it that editors are not completely out of the way if and only if the speech is harmful and is not at all contributing to public debate, but is not speaking about truth or things it may think to be true, but is openly providing us with wrong information. That is, of course, very delicate exercise. Probably that's why I think balancing, even if it's not as popular in the United States as in Europe or in Germany, is probably the way to go. That makes regulation so difficult. And if you look at the GDPR and all sorts of regulation we have already, it's very cautious and is always leaving space for balancing of rights and not giving. So sometimes it's difficult. You can't get you have a clear-cut question and you don't get a clear-cut answer, but they say, well, it's about balancing, and it's about balancing by the trier of fact, not really any higher court, but the trier of fact should balance things out. And that I don't think that is avoidable in the long run. Still, these are huge questions, and they couldn't be more important for democracy and for the future of rights, because we also do not want rights to be at the mercy of governments either. That of course is also true. So I think yes, we need the state more. Maybe the state is getting into the role of an arbiter, of a rule maker and rule enforcer, and seeing to the fairness of the rules, then one which would determine the rules, which will give us a variety of networks, but which will also give us some networks we would rather not have.
And I'm going to follow up with another sort of philosophical question, although really it's more of a predictive question than a philosophical question. In the United States, there's enormous concern that our commitment to freedom of expression, which was thought to be the cornerstone of democracy, when it is filtered through the business models and practices of social media companies, will ultimately undermine democracy and make democracy harder to achieve in the United States. And now, of course, the Americans are always, less interested in regulation than the Europeans are, to be sure. But I want to ask you this question from a European perspective. Given what you have seen already, the laws that have been passed already, and also the laws that are currently being considered, are you more or less optimistic about the survival of democracy in this new digital public sphere?
It's a difficult time to be optimistic. I'm the least optimistic of my whole, if I take my own conscious life, I would say I'm less optimistic than I ever was democracy in this new world. On the other hand, I still value very much this possibility of individuals to get their views heard. Actually, we probably need to think hard about the way how we get the one and we keep the one and not lose the other. Because of course, if democracy cease to be innovative, if there's only one general view which is imposed from up down, that is also very dangerous indeed. And of course, we have another big country which in our tradition, we do not want to adopt this view where you get social points for everything you do, either positive or negative. And we don't want to have general surveillance. But yes, when in the time when autocracy is back, of course, also the temptation to control everything is also back and is stronger than ever. We are speaking not of the internet anymore, but of splinternet and all those developments. But so far, I think we have practiced democracy in the Churchillian way. You know, we have exercised every possible way, and in the end, hopefully, we adopt a good one. Maybe not the best one, but a good one, and probably the best one because when it is legitimate from a democratic standpoint, it is much more. Even if it is, you know, not ideal, it has much more staying power, and it is followed by conviction. That's the way to solve issues. But frankly speaking, this is a time where all matters of course are gone. As a law professor, I would say we have to start always fresh and anew. We should never take things for granted, and that's also probably true in this globalized media world.
Good. I'm going to move from this very difficult philosophical question and ask you a much easier descriptive question. Americans are very interested in the new proposed Digital Services Act. Could you tell us a little bit about what this act is going to do? To what extent does it borrow from ideas in German law? How will it transform social media regulation?
Well, that's difficult to tell because we don't yet know what will be finally in this thing. It is about provider obligations, liability of providers. I have it in front of me. I don't know that all by heart. There are a lot of different things. Is it hosting? It's about what are those information services allowed to do and what they are not allowed to do. And part of it is indeed borrowing from the German idea of the Network Enforcement Act and orders to act against illegal content, orders to provide information. So they get the full amount of obligations, due diligence, transparency, safe online environment, and so on. Very much borrowing from this Network Enforcement Act, but adding other obligations. Notice and take down, for instance, if something illegal is still there. There is, in parallel, there's a copyright law which is already in force, a copyright directive, which seems that there's a small dispute still about it, but most say that it requires some sort of automatic filters for online content. And of course, some say that that is a problem because those filters, automatic filters, are problematic because most computers have not that that great amount of humor, it seems, these days, and that creates problems. We shall see how this turns out. Germany has put forward an implementation of that directive, which would be much more, which would also see to it that there's a procedure that some person and not only a computer is checking that content, and there's some sort of minimum clause, of minimum relevance clause before they can apply, etc.
Can I ask you I just ask you to make this a little clearer for our audience? So from the standpoint of the way Americans talk about it, the question is whether or not the new Digital Services Act will impose any obligation to monitor content and so that it can promptly be taken down, as opposed to simply responding to requests or objections, right, after publication. This is really the way in which the Americans tend to think about it. Now, that can be done either by individuals, or it can be done by algorithms, artificial intelligence, or it can be done through a combination of both. Now, as you understand it, the draft is going to have some new duty to monitor. Is that correct?
Yeah. As I understand it, it is dealing with, it has some provisions not copied, but more taken up from the network enforcement law. And therefore, there is an obligation to notify suspicions of criminal offenses. And let them probably not remove them themselves. That I don't see in the current draft, but it may well, very large online platforms get more obligations, and they may have to remove that stuff. But there must be always some sort of independent control. So actually, that will give them lots of additional information. I don't yet know, frankly speaking, whether it will also require them to remove content before there has been some sort of arbitration or some sort of independent decision making of whether this content can remain there or not. It's a very complicated thing already, containing lots of obligations for the providers, obviously.
Yeah. So I want to, before we turn into questions from the audience, I was going to ask you one last question, and it's very simply this. You know American law and background, as well as European and German law, and you also know the developments that are occurring in Germany and Europe. Is there any advice that you would offer lawmakers in the United States who are debating dozens of different proposals for internet regulation, privacy regulation? Is there anything in particular you advise them to adopt, which would be a good idea in the American context?
Well, probably I must be careful here. Of course, I'm not there to advise American legislators. That's not my job. I'm also not in the business of advising German legislators, for that matter. But one thing probably is obvious in all those acts of regulation. There must be some sort of possibility to get to an independent reviewer of difficult questions, and probably we need some sort of, some would say bureaucracy, others would say we need to adopt some sort of independent oversight. I think that is it's not working without. At least that is the experience we are having. But having said this, second point, of course, there needs to be a balance struck. It's not one-sided. It's not, as a little bit the title of this talk, which is, of course, attracting interest as well, is suggesting it's not the good versus evil thing. It's a fine line between, maybe outrageous speech, but still permissible speech, and criminal content, which is only denigrating people, but just has no serious core to it. That is very difficult in the offline world, and it is even more difficult in the online world. But I think there is not this one general rule which would make it easy. There is some sort of balance required, and you can't. I mean, there are easy cases, obviously, but to demands to kill people or whatever, that I think there also is European and American ideas are not that different, but that's not to be accepted. But there are difficult cases, and they need to put some balance in, I'm afraid. And I know that my US brethren are not so keen on balancing and on proportionality and these things. But our experience is we couldn't do without it. Let's put it that way.
Yes, thank you so much. Georg, I think it's time to open up the floor for questions.
Okay, thank you very much, Jack and Andreas, for your comprehensive yet still deeply engaging conversation. I think we've learned a lot from you, and now I open the floor to the audience for questions. and comments. Now,
I think, Justice Paulus, they're very shy, which is very unusual for members of the Information Society Project. They usually have lots of questions.
I
right.
can only say, please ask. There is somebody, please ask questions. You have the right to ask every question. The only thing which can happen is that I have to apologize for not being able to answer it. But that's my problem, not yours.
All right, so I have a first brave speaker now. Claudia, please.
Hi, thank you so much for this talk. This was a really interesting conversation. So I feel like there's been a bit of a turning point in the way that we in the US talk about these issues ever since January 6th. And I feel like, the sort of optimism, I think that Jack was alluding to, has waned a little bit. More speech is not always better, as it turns out. And what I found intriguing was that in sort of popular commentary and sort of newspaper op-eds, this theme of militant democracy started to appear. And of course, from the German perspective, that's something that we've lived with for a long time, and sort of that general idea. And I was just wondering if you could sort of explain a little bit what that means, and if you see anything that it sort of bubbled up in kind of general terms, just sort of, there is such a thing as militant democracy where democracy doesn't have to, tolerate free speech that then is used to undermine it. But if you have sort of a few thoughts on whether there's something that in American legal discourse we can learn from that. Thank you.
Thank you very much for the question and for the kind expectation that we could tell anything to our American friends, which could be useful for you. Yes, a militant democracy is a big topic. And frankly speaking, what I don't like about these terms is the militant part. It's not about the state, being militant itself. It's about, we call it in German, wehrhafte Demokratie. That is a democracy which can defend itself. It is more defensive than offensive. Militant is, marching for some positive purpose. Our idea of a defensive democracy, of a democracy which is defending itself, is when it is under threat, that there is, that it does not simply let go and say, well, as a democracy, that's a Weimar experience of 100 years ago, that if you say, well, in the end, democracy will prevail and we let everything flourish, then you may, in the end, you may have helped those who want to abolish democracy, and democracy is gone. And therefore, we have this idea of a defensive, of a democracy able to defend itself. And that also means, and may mean, unfortunately, restriction to some sort of speech, which may undermine democracy. I hasten to add that that's not something we do lightly, and we do every day. There was a debate in the 1970s about a decision on extremists in the public service, which needed to be removed. And it is one of the laws which are more talked about than applied. Until this day, it was declared illegal by a UN body and by the European Court of Human Rights, at least as applied in some cases, and so on. So actually, we don't yet know whether our democracies are able to defend themselves in a way. But it broadens the possibility to ban certain political parties, for instance. Recently, the Second Senate of my court has not banned a party simply because it was not powerful enough. If it had been more powerful, it had declared, in fact, its goals for unconstitutional, but the party not important enough. If you read the party platform, you will well understand why. It almost reads like a party some 80 years ago. And of course, that's something we don't want to have anymore. And that is the experience, of course, from which this view of militant democracy is born. Is it helpful in the free speech environment? That is a very open question. Maybe the lesson is, yes, it is allowed to prevent certain speech from being distributed. Then it is getting dangerous, not only for private persons, but also for the democracy as such. But where is such an instance? That is very difficult to decide. So militant democracy is rare, and I'm not sure that it helps against the everyday threats. What might happen, where it might be applied is indeed when there is some sort of attempt to undermine the democratic system, and that is to be prevented. But look at the party ban story. The problem is these party bans are mandated in the constitution, so actually, of course, we are implementing them at the court and trying, of course, to be very careful about it with regard to the democrat, because the original democratic right is at play of voting for your views, and therefore you have to be very cautious about it. The problem is when also of the judgment of my court, which I completely agree with. Not to be misunderstood, but nevertheless, even things you agree with have sometimes problems. And the problem is when you say it's not important enough and therefore we do not ban it to show that actually we are not very concerned that they could be successful, then, but what are you going to do when it is more influential? Are you then, as a court, having the courage to ban it when it has mustered 20, 30, 40, 50% of the vote? That is an open question. We don't know because we have never been before such a situation.
Okay, so the next one is Art. Art, please.
Thank you. This was so fascinating. The conversation you had. Thank you. I was wondering if I could go back to the discussion you were having of editors and the unappreciated role that editors played in mediating the public sphere. And I wanted to connect that to the stadium ban decision and the logic that the Supreme Court has taken in extending that to social media. And so in a sense, it seems like the enforcement of house rules in the stadium ban is rather mediated by the purpose of a stadium, which is quite straightforward in it being attending a game. Whereas we're not so clear as what is the purpose of a social media or what are acceptable behavior or even normative behavior in social media. It seems that is currently the most controversial idea. And so when we think about editors, it seems, and Jack has written about that, it seems that editors are not only playing a role in deciding what kind of speech is legal or not, but they are actually developing on the basis of professional norms, what kind of speech is valuable or not. So they are, in a sense, co-developing the public sphere on the basis of those norms. And so I think my question would be, when we try to translate that logic that we have in the stadium ban decision to the context of social media, where we don't have a clear purpose onto that, what the purposes of those contexts are, and we don't have professional norms, is the idea of just insisting that private actors must adhere by fundamental rules, fundamental rights, is that a good model? Might there be a sense that we're trying to privatize the development of these new social norms to actors that are not motivated by public interest? Sorry for the long-winded question there.
Thank you very much for this question. It gets us back to Jack's philosophical question of the other moment, which I certainly did not fully answer. probably it's not, cannot be fully answered anyway. How much can we substitute those editors for, or should we anyway? Because we need, if you speak about legal philosophy, we need Dworkin's Hercules, you know, for not as a judge in the end, but probably as an editor to decide which speech should be admissible and which speech should not. And that, of course, is something. Well, probably most of us have not gone into the legal business because we wanted to tell people what they are not allowed to say. You know, that's probably not the main purpose of the freedom of expression. But sometimes, yes, you need probably some sort of regulation, and a public forum must remain public. You know, if a forum starts to exclude certain people, but yet has some sort of and that I think is an important element. You need some sort of monopoly. Both we have two conditions basically in the stadium ban decision, and whether or not you can transfer them to the public sphere is open to debate. The first criterion is some sort of monopoly on a forum, be it for enjoying games or be it for discussing politics or the most recent or sports or musics. And secondly, however, monopoly may not be enough. The second point is that it is a social service, which is important. So it borrows a little bit from private law that if you are the only water supplier and you need water to survive, then of course you have to offer water supply to everyone in the village and or the town. Also those people you may not particularly like or who may not, in your view, contribute to society or whatever. No, they all have their right to water and they all have to get their water if there's only one water supplier. When there are lots of small networks and you have the choice to be in a conservative network or in a liberal network or in a socialist left network or whatever, then that is fine. Then you have in the traditional press regulation, there's this idea that when competition works, when there are you used to have so many different newspapers. A lot of local markets, you don't have that anymore, but you used to have so many different newspapers so that you didn't need to care for their inner pluralism. But if you have only a few of those networks, and they get, of course, much more important, and then you have to see to it that there is some sort of pluralism within the service. That is the core of the German broadcast regulation. There is a control body which is not a state body and which needs to be composed in a pluralist way. And we once removed this body because we said it was not pluralist enough. The state influence was too large. I don't want to go into specifics here because it gets very complicated. And I don't want to suggest either that there is a central board somewhere in the world which is going to be the final arbiter of all those issues. When it is a wise body, it will refuse to do something like that. But that there is even if you have more than one social network, but if you have very substantial networks which have a sort of monopoly for a certain way of a certain part of the public discussion, you may consider whether that is a similar situation where you need some considerations for rules. And you have state courts telling the Football Association, or we have the Federal Supreme Court telling the network that they have at least to give a hearing to the participants in the discussion. And then you have must have a fair body to decide about the issue. So that there is some social responsibility built in the system. And it's probably not enough, as there's territory for me now, but maybe not enough to do this only on your free will. Maybe there needs to be some procedure to check whether that really happens. And it may be helpful for networks as well, because we presume, or we should presume, that there is a good intention to have a real discussion and to admit people and only reject those who who cannot really be part of that discussion, who don't want to be part of the discussion, but who want to throw people out rather than bring people in.
Okay, if I may, this last answer that Justice Paulus offered really throws a very interesting light on the topic of internet regulation. So if you would allow me to be experimental for a second, Justice Paulus. Imagine, yes, imagine that instead of passing the Digital Services Act with respect to this question or NetzDG, Germany and the European Union instead had focused almost exclusively on antitrust. Imagine that it had seriously broken up social media companies into smaller bits. Imagine that failing that, in order to defeat the problem of network effects, it had required interoperability so that a small system could interoperate with others, so that there could in fact be 50 little Facebooks, let's call them 50 little Facebooks. And so that everything was done to promote diversity, pluralism, and many, many players. In that case, it would strike me that the NetzDG Act would not apply by its own terms to almost all of the players and the vast majority of digital speech. And indeed, it would not be even clear if the NetzDG Act was even required, because in fact, all the players would be too small. And yet, seems something to be paradoxical about this, since I assume that the reason for the NetzDG Act was in fact a desire to regulate most of the field of digital speech, which also brings me to another puzzle. And again, this is not a legal question. It's rather a question of thinking about how we organize the space. It has always struck me that although the United States and Europe talk constantly about competition law and antitrust, they really don't want competition law and antitrust with respect to these large players. And the reason why is it's very convenient for nation states to have a relatively small number of big players, either because it's easier to regulate them or because it's easier to work with them. For example, the United States government works with the big players in things like terrorist recruitment, and all of the countries work with them in cases involving child pornography. So there's a sense in which they look at it from two different directions. They both would like there to be a bunch of small companies, and they don't want there to be a bunch of small companies because it's hard to co-opt them and get them to cooperate. Now, again, it's not a legal question. I just wanted to know what your view is about this paradox.
Well, yes, there is such a paradox. And yet, maybe a plurality of networks is not the problem, but is part of the solution. So the need to regulate, the perceived need to regulate and to have a network enforcement act, for instance, was that there is even criminal hate speech on those webs, and we have to do something about it. And they are so important, what happens in those networks. I mean, we had cases in India where those networks were used, in fact, to create riots and so on. There was real violence involved. There are real people suffering hard from instances of. And we have another problem, which we have addressed in a side argument and in the chamber even, that you don't find in a lot of instances no local people who want to be in public office because they are abused in such a way that they say, why should I do this to myself, and even worse, to my family, only to play a social role or to be a politician or so on. There are lots of people who just don't want to do that anymore. That's also not bad for democracy, because it may happen that the best people therefore will not be available for public office and things like that. This was a perception that you need to do something to implement, to enforce. That's also, that explains this funny name. You want to enforce the laws on that network. So if you have small networks, the idea was not necessarily that was needed. And there was a certain hope that more competition would be helpful and not harmful to the way a public debate is happening. Whether that is true, this prediction, we don't know. We have lately there was, I'm also responsible for competition law in the Constitutional Court, so I have to be careful here. But there is a case in which the federal office has actually attempted to implement competition laws. And of course, there is the Digital Market Act, which is actually far more advanced than the Digital Services Act. And Germany actually has also put some of it already into domestic law before the act became mandatory. This means that there is this certain hope that competition is a solution. Do we know this? I don't know. Maybe yes. Maybe we will see that. At the moment, there seems to be more of a feeling that there is at least an oligopoly and not enough pluralism. But I would be cautious to make predictions on how this turned out. It could be that, you know, there is that now this is even multiplied, that you have hate from every corner then, because you have several networks, and they may be all powerful enough that you to get yourself in trouble, and not some local network in Australia which doesn't bother you in Germany. That may not work out that way. And so probably we just don't know. Competition would mean that if we apply competition laws, we must have the hope that competition is part of the solution. And I'm not sure whether we know that yet.
Right. So, Andreas, I think now I think that we have still a question coming from Carmen. Okay, so Carmen, please.
Thank you very much. Just a quick question. So, as you know, the internet is global, of course. And so I was just wondering your thoughts on the impacts of domestic regulation or regional regulation in the case of the EU on sort of the global internet, and whether or not you think laws should be crafted keeping in mind potential impacts outside of the borders that the judges or legislators or whatever are, like, beyond just their particular borders. Because I guess a potential concern is that on the one hand, that you're going to create a race to that we're already starting to see a race to the bottom in terms of regulation. Like, whoever has the strictest regulation basically sets the regulation, because companies don't want to comply with different kinds of regulations, so it's easy to just comply with the strictest. On the other hand, you have like a potential splintering of the internet. The easiest example here is China, with some of their rules that are just de facto keeping companies out for multiple reasons. And I also wonder if there's a kind of paradox similar to what Professor Balkin was describing, where the more rules you have, it seems it raises the cost of compliance and therefore the cost of market entry. And so it makes it harder for potentially new actors to come in. And so I'm throwing a lot at you. I was just wondering, I was just hoping to get some of your thoughts on some of these dynamics as well. Thank you.
Well, thank you very much. You have, I think, very well defined part of the problems that we have. And there was in fact, you have described the secret of the international success of the European data regulation, because it was the one, apparently the fullest expression, you know, of these data protection ideas, and a lot of companies have adopted it. There was an interesting view of some companies saying, we will adopt the regulation, but we will do everything to flee the regulators. So yes, we accept the rules, but we don't accept the European Court and etc. And that was part of the decision of the European Court of Justice, was, interestingly enough, that for the question of whether a certain ban on Google, for instance, applied internationally, the European Union was not competent, but the member states were competent and had to decide on whether a ban on let's say, hate speech on the internet should also apply on a search engine, should also apply elsewhere. Or the right to be forgotten should apply elsewhere. That's interesting because that means that all those member states are now on their own. Normally, you would think, if you would regulate this thing, you would all say, of course, it is a European Union issue because that is about the international effect. And there, the European Union is much more powerful and influential. But that was not what the current law says. Doesn't mean that that is going to remain like this, because it is at least counterintuitive. That's true. On the other hand, you have said, and I think you are right. Of course, there is a certain danger that the smaller actors will have much more problems with these big regulatory works than the big companies. The big companies have their legal services and they have their own legal people, and they can go to the market and buy it in. They have enough money, and therefore they can buy themselves the best legal advice available, and so they can cope, whereas the smaller ones cannot. That is a very reason why, an additional reason I failed to mention the other moment, why small actors are excluded from part of the regulation, exactly to allow them to have entry. And indeed, in Europe, a lot of people say we have an interest in having European networks developing along with the big American networks. That is one of the reasons why it of course interesting for economists, but I don't know much about it. I'm not an economist, but to me this sounds very much like the infant industry argument of the 1960s and 70s, which have not worked out very well, actually. So we don't know what that, but it is a completely different enterprise, and that's why we don't know this, whether that will have this effect that only the big ones can actually cope.
Thank you.
Right. So perhaps before we put an end to this wonderful session, I could still ask you a question, Andreas, because we've talked so much about social media and so on. So it is actually a predictive question. So it might be easier. So we have in this room, talking about constitutional interpretation, we have here the creator of a theory of living originalism. So, and we know that the German law on free speech is born subject to the dignitarian interpretation, actually, of all constitutional rights. So, but we also record the nice tradition of the echoes between American jurisprudence and the German ones. For instance, the Sullivan tradition was well echoed by the German Federal Constitutional Court in the 60s as well, in the Lutz case. So my question is how likely do you think the German Federal Constitutional Court might perhaps follow its own dignitarian interpretation in regulating the social media, or is it more likely to perhaps again echoing some of American jurisprudence? And for instance, let me be straightforward. Just when would it be possible for the German Federal Constitutional Court to explicitly impose a kind of an obligation on the social media, saying that you must have an obligation now to respect free speech?
Well, of course, I'm not in the prediction business. As a lawyer, we are much better in actually applying living constitutionalism. That pretty much describes what we have done. A lot of us have done, although there is no general theory of interpretation by the German Federal Constitutional Court. There are only very few ones. One of them is if you know well what the original drafters have said, this is the limit of interpretation. You cannot go beyond that. But of course, most of the times we don't know this for sure, and particularly when it applies to new situations. So indeed, I would say, at least my leading philosophy would always be to try to understand what the intent, purpose, and content first before intent and purpose of the original draft and drafters was, but then to try to transfer these ideas in today's world, translate them into today's world. That does not, it may be mistaken to believe that the things mean today. Even if they had lived today, they would be different persons, and therefore it's not necessarily so that this means that we have to follow, to come to the same results, even when we apply the same principles than the original drafters. Well, think of course of the Declaration of Independence famously, and of the practice of slavery, which was completely incompatible with the ideas expressed there. And things like that is in a much more ordinary and much more lower fashion are very often to be found. So that's the first point. The second, to try to understand what it meant in the original context and what it meant in the original society, but then transfer the ideas, the normative part into our today's world. And secondly, and that may transform, that may change the result even if the principles and the norms are not changed. And secondly, on what was your second main point? Sorry. Could you repeat?
Oh, you mean my question?
Yeah, the question.
The social media, so regulating the social media, and would it be possible?
Yes, would be as court mandated. Well, there is one thing, of course, to defend individuals from state interference and also companies from state interference on the one hand, and on the other hand, to extending obligations to them. But in a way, this strict separation of protection on the one hand and intervention on the other hand is I think, too simple. If you want to, and you mandate to prevent torture, you need to ask for a procedure to regularly check, because we all know, of course, that banning it simply in the law books will not be enough to ban the practice. Then we want to prevent private views, dominate other private views, when we want to have a public debate worthy of that name, then we will have to protect speech, and not only to protect it from interference, but also to do something so that it can express itself. We have done so, for instance, in broadcast regulation. And the most difficult question in the internet age from that view, which of course is a much more interventionist view than probably held by most of our American brethren. If you want to, whether and how you can transform this to the internet world is not yet decided. I mean, a lot of people were laughing about Angela Merkel when she called the internet new land, and everybody was saying, oh my God, she has slept over the past 30 years of technological development. That was not what she meant, The Chancellor meant, of course, that we have still not found out a general way of regulating it and to transferring the insights from the offline world to that online world. And maybe we need a parallel regulation to the broadcast control in Germany, which is one of pluralism, not preventing speech, but letting all different speech reaches flow. And maybe we need something also ensuring that kind of pluralism on the internet, and at the same time try to prohibit practices that prevent other speech pluralism from emerging. Whether this is the task of a court very much depends on which laws you are expanding. Whether it is a task of a constitutional court without any law as a basis, well, that's very, very difficult. Usually what we do is very often a lot of different contexts. There is a law done. It may not have done it well enough. So what we try to say is this fundamental right or that fundamental right requires reconsideration of this or that article which has been attacked by an individual complaint. we rarely do this in the void. So if you go to the Constitutional Court and say we need urgently a law on this or that practice, that is unlikely to succeed because I cannot be included. Depends on the case, but that is unlikely to succeed because this kind of some people say also that usually the first one who is applying, who is making regulation and also applying fundamental rights is Parliament and not the courts. The courts are the last in line and may check what Parliament has done, whether that conforms to the Constitution and to the individual rights of citizens. But that there would first, be a constitutional complaint that the Constitutional Court should directly regulate things, that is unlikely.
Thank you very much, Andreas. And with that, I might ask, please, everybody to give our two speakers our sincerest thanks and applause for today's session. Thank you very much for your kindly agreeing to take part in this session. Thank you very much.
It was a great pleasure. Thank you very much for listening.
Thank you very much.
Thank you for making this possible. Bye-bye.
Thank you. Thank you. Bye.